welcome everybody to today's webinar. Today we are talking about making a human rights complaint in British Columbia. My name is Paula Price. I'm with the People's Law School and I will be your host and moderator for today's webinar. We will be joined by two wonderful guests, Catherine Hardy and Kaylee Schiff. I will be introducing them in just a few minutes. We are talking about making a human rights complaint in British Columbia. Topics that we will cover, we will be talking about what amounts to discrimination, what options you have other than making a formal complaint, factors that you may consider in deciding whether or not to pursue a complaint, and then finally, steps in the BC Human Rights Tribunal complaint process. We have got 60 minutes together. What you will receive today is answers to common questions, and we are providing legal information as opposed to legal advice. If what you're looking for is the law as it applies to your unique set of circumstances, then we recommend that you seek legal advice. You're welcome to reach out to a lawyer. You're welcome to reach out to our speakers and their respective organizations. The contact information is on the screen. The information that we share with you is, of course, current as of today's date. Now, we would like to acknowledge that we are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we encourage everybody who is watching to think about and reflect on where they are joining us from today. We'd also like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose financial support makes production of these webinars possible. And finally, we would love to thank and welcome our speakers. We have Catherine Hardy and Kaylee Schiff. Now, Catherine is a lawyer with the BC Human Rights Tribunal, and she has been with them for over 30 years. The Human Rights Tribunal, as you will learn, you'll learn more about it in today's discussion, is responsible for accepting, screening, mediating, and adjudicating human rights complaints in British Columbia. Catherine, we are so delighted to have you. Welcome to today's webinar.
Thanks, Paula, and hi, everybody out there. It's great to be here. And I will just mention that I'm joining from the Tribunal's offices, also on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh peoples. It's wonderful to be here.
Wonderful. Thank you so much, Catherine. I would also love to welcome Kaylee Schiff. Kaylee Schiff is a return speaker to the People's Law School webinars. She is also a lawyer. She is a lawyer with CLASS, which is the Community Legal Assistance Society, a nonprofit law firm that has been serving British Columbians for over 50 years. She works within the Human Rights Clinic, which provides representation to complainants who have cases before the BC Human Rights Tribunal, as well as information to prevent discrimination. Kaylee, welcome. It is such a pleasure to have you back.
Thanks so much for having me back. I'm very excited to be here. I am joining from my home office today, which is also on the unceded territories of the Musqueam, Squamish, and Tsleil-Waututh peoples.
Wonderful. Thank you so much, Kaylee. So with that, we're going to turn to our first question. And Kaylee, this first question is for you. What is discrimination and what characteristics are protected by law?
Thank you for the question. This is a really big question. So in BC, the piece of law that defines what discrimination is under the law and makes it illegal to discriminate is called the Human Rights Code. And it makes it illegal to discriminate against people in certain protected areas of life. And so Catherine is going to give a bit more detail about what those protected areas are, but the big ones include employment and housing and services and facilities, but there's a couple other areas too. So discrimination is when someone experiences a negative impact in one of the protected areas, like I said, like housing, employment, services, and when that negative impact is connected to one of their protected characteristics. So the Human Rights Code does set out specifically what those protected characteristics are. So I'm going to list them for you. It includes Indigenous identity, race, color, ancestry, place of origin, religion, marital status and family status, physical or mental disability, sex, sexual orientation, gender identity or expression, age, which applies only to 19 years of age and older, political belief, which applies only in the employment and union context, and then lawful source of income, which applies only to the tenancy context, and lastly, unrelated criminal conviction, which is only for the employment context. So, in order for someone to show that they have been discriminated against, there's three factors that need to be present. The first one is that they have a protected characteristic, something race, their family status, disability, that something negative happened to them in one of the protected areas like housing, employment, or services. And then importantly, that there's a connection between that negative thing that happened and the protected characteristic that they have. And so that's a kind of a broad definition. It means discrimination. The kind of conduct that can be discrimination can look like a lot of different things. It could be, for instance, stereotyping or unfair assumptions about someone based on their protected characteristic. So maybe comments or jokes at work that are based on someone's place of origin, for example. It could also include bullying and harassment. So maybe like sexual harassment, that might be sort of unwanted sexual advances, or sexualized jokes or comments at work. And it is important to know that not all bullying and harassment is going to be discrimination, because sometimes, as awful as it is, there's bullying and harassment at work. And if it's not connected to one of those protected characteristics, then it just doesn't fall under the Human Rights Code, and it's not discrimination under the Human Rights Code. And other examples of discrimination could be like singling someone out or profiling them based on their protected characteristics. So maybe a security guard following an Indigenous person around a retail store based on their Indigenous identity. Or it could be other forms of exclusion or disadvantage. So maybe someone being denied entry to a restaurant because of their religion, for instance. And so those are just some examples, but discrimination, it can be both direct or indirect. So direct discrimination is when someone is treated differently in a way that disadvantages them. That could be, as an example, let's say women in a workplace being assigned different tasks in that workplace than the men. So maybe they're being assigned things like cleaning the bathrooms, and the men are being assigned more desirable jobs, let's say. That would be an example of direct discrimination. But discrimination can also be indirect. So that is when there's sort of a rule or a requirement or factor that is maybe not discriminatory on its face. So maybe it's a rule that applies to everyone equally, but it could still, if it's applied to everyone, result in an exclusion or disadvantage because of some people's protected characteristics. So just an example of that might be a workplace that has a requirement that every staff member be available to work on Saturdays. That may seem neutral because it applies to everyone equally, but it could be indirect discrimination because it would exclude members of the Jewish community who, for instance, practice Shabbat on Saturdays and are prohibited from working. And so sometimes treating everyone equally can also in and of itself be discrimination.
Beautiful. Thank you so much, Kaylee. Catherine, this next question is for you. And it is, what is the Human Rights Tribunal, and what role does it play in protecting British Columbians from discrimination?
Thanks, Paula. The tribunal is an informal court that specializes in human rights. I'm going to talk more about what the tribunal does later. Right now, I'm just going to mention three things. First, you make a discrimination complaint directly to the tribunal. Second, the tribunal does not investigate human rights complaints, and that means that you need to collect documents and witnesses that could help you prove that discrimination happened. And third, at the tribunal, if the parties are unable to find a solution to their complaint, the tribunal will hold a hearing to determine if discrimination happened and if it did, to order a remedy for the discrimination. You should also know that there are 2 other human rights agencies in BC. People often get these organizations confused, but we each have very different purposes. In addition to the tribunal, there is the Human Rights Clinic, where Kaylee works. They specialize in helping people with their human rights complaints. The tribunal is not able to give legal advice, but the clinic gives legal advice and representation to complainants in some complaints. The other organization is the Office of the Human Rights Commissioner of BC. The commissioner generally works on broader issues like education and research. The commissioner is not usually involved in human rights complaints and does not provide advice, and it does not investigate human rights complaints like other human rights commissions in other parts of the country do.
Beautiful. Thank you so much, Catherine. Our next question is also for you, which is, I know I'm protected from discrimination at work, but what about other places?
Kaylee mentioned some of them. There are 4 main places or areas where you are protected. So work is the most common area of human rights complaints, and it covers everything from job advertisements to applying for a job and not getting it, discrimination while you're at work, and discrimination when you are fired. You are also protected from discrimination if you are denied a public service or experience discrimination while you're using a public service. And there are all kinds of examples of public services. They include stores, restaurants, hospitals, services provided by strata plans, services provided by provincial and municipal governments. Another protected area, as Kaylee mentioned, is housing. So you are protected if you are denied a rental. So if you're seeking to rent an apartment, you are protected within your tenancy. So for example, against discrimination from a landlord, you're also protected if you're evicted. Another part of housing is purchase of property. So you are protected against discrimination when you are buying land or a house or a condo. And then the final and 4th area of protection is publications. And that includes things like discriminatory flyers or newspaper articles.
Beautiful. Thank you so much, Catherine. This next question is for you, Kaylee, and it dives into an example that can happen at work. I went through a period of depression and missed a number of days of work. I told my employer that I missed work because of a period of depression. My boss said there was nothing they could do and fired me. What is the duty to accommodate, and how far does it extend?
So, in answering this question, I'm going to be talking about the employment context because that's what this question is about. But but also the duty to accommodate, just so everyone knows, it applies outside the employment context too. So it applies in all those other areas that Catherine just mentioned. So in your strata, in your tenancy, and services, etc. So if an employee is experiencing barriers to their job that relates to their protected characteristic, like for instance, a disability, then an employer has a duty to make reasonable accommodations for its employees' needs as those needs relate to their protected characteristic. So the most common example is probably in the work context when an employee has a disability that's affecting their job, their employer would have a duty to make reasonable accommodations for that person's disability related needs to make sure that they can work. So for instance, an employee who suffers from a disability that maybe means that they can't sit for a very long period of time, that employer would have an obligation to accommodate them. And that might mean doing things like buying them a standing desk and making their physical workspace set up so that they're able to work despite not being able to like sit at a desk, for instance. And so that duty for an employer to accommodate their employees, it only extends up to the point of undue hardship, which means if an accommodation would be undue hardship on the employer, then they don't have to do that accommodation. But it might mean that there's still other accommodations that are maybe a little less perfect, but that are still reasonable and that the employer is still able to provide. So they couldn't just say, well, that accommodation you want is too much, we're not going to do anything. That they would still have a requirement to try to be flexible and come up with accommodations that are reasonable. And what is going to count as undue hardship is different in every single case. But there is an expectation that there will be some hardship involved in the whole accommodation process. So there is probably going to be a financial cost. There's probably even going to be a great deal of inconvenience. I mean, not necessarily, but a lot of the time. And those things alone don't usually make it undue hardship. So for instance, if there's in a strata, there's a resident who requires a ramp so that they can use their wheelchair to access the building. A strata, it might need to pay quite a bit of money and spend quite a bit of time arranging for a ramp to be installed. But those alone probably wouldn't make it undue hardship. But it is dependent on every single context and the situation of every strata and every disability and what it requires. But an employer or duty bearer would have to show that they couldn't have done anything else reasonable or practical to avoid that negative impact. And so what that accommodation process looks like is also different in every single case, because how a disability affects people and everyone's situation is just so different. So an employer really needs to be flexible and consider creative ways of making that accommodation work. So for instance, that flexibility might mean deviating from a rule about attendance. And so, we don't have all the background information for this example, but let's say this employer has a sort of 3 strikes and you're out policy when it comes to missing work. Well, a policy like that, when applied to someone with a disability like depression, might not meet. That might mean that the employer isn't meeting its duty to accommodate if they apply that rule very strictly to that employee. So their duty to accommodate might mean relaxing that rule and not applying it to that employee, but coming up with some other kind of solution to ensure that employee's barriers to working and maintaining their job are lowered or removed. And then also important to know that the person who is seeking accommodations, it's not a one-sided process. So the person seeking accommodations also have some obligations. It might mean that they have to actively participate in that process. And it might mean providing things like medical notes or other medical information and answering questions about their disability or whatever the protected characteristic is, in order for the employer to be able to assess how they can accommodate that person. And it also might mean that employee has to accept reasonable accommodations. So the process is not about finding perfect accommodations or the ideal accommodations, but about finding something reasonable.
Excellent. Thank you so much, Kaylee. This next question is for Catherine. Catherine, this is the fact pattern that Kaylee alluded to just a few minutes ago. Here it's in the context of a retail store. I am a member of the Musqueam Indian Band. Recently, I was browsing at a clothing store. The security guard followed me around and accused me of shoplifting as I left the store. I suspect it's because I'm Indigenous. What options do I have other than making a human rights complaint with the Human Rights Tribunal?
Yeah, there are a few things that you could consider. You could contact the store manager or property manager or the security company that employs the security guard and offer to meet to discuss what happened. Depending on your comfort level, you could do that in person, in writing, by telephone. You could also see if there's a complaint process in the property where the incident happened. If you think that there is a pervasive problem in the community, you could also consider contacting the local Business Improvement Association and suggesting to them that taking steps to ensure that there are safe spaces for everybody in businesses would also help business. In some cases, you might be satisfied with the response that you get, or you might not be. You can still file a human rights complaint. One thing to keep in mind is that the store or security company, they may tell the tribunal about the communications you've had with them and tell the tribunal how they responded to your concerns. And they may even argue to the tribunal that it should not proceed with the complaint because they've done enough to address the concerns. And if that happened, you should just know that you would have a chance to have your say, and then the tribunal would decide what to do.
Excellent. Thank you so much, Catherine. Haley, a question in the employment context. I feel like my employer has singled me out because I have young kids at home. They give all the good work to my male counterparts who do not have kids, and my career is stalling as a result. I'm not ready to make a formal complaint, but I need to say something. What options do I have?
Yeah, so just to reiterate the protected characteristics, sex and family status are protected under the code, and family status does include things like whether or not you have kids, for instance. So there is protection on those protected characteristics. But in terms of what you would do either before or instead of filing a human rights complaint, I would first take a look at what kind of things you could do internally. So it might be, if you're comfortable, you could start with having a frank conversation with your boss about what's going on and finding out what needs to happen in order for you to get the same career benefits as the childless male counterparts. And maybe and hopefully that boss would be receptive and it could actually make some kind of difference. But if not, or if you don't feel comfortable doing that, your workplace might also have a human resources department. And sometimes there's either informal or quite formal processes for dealing with issues like this that could resolve this issue. And then also, if you happen to be a member of a union, unions are a really good resource for dealing with discrimination in your workplace, and can often assist you with things like this. So I would utilize your union representatives if you are in a union. And otherwise, I mean, I would say this isn't so much a legal perspective, but one thing to consider is also potentially looking for a job somewhere else, and somewhere that will value you, that like won't hold you back because of your sex or family status. And I know that option isn't available to everyone, and it might also not be the most satisfying result, but also sometimes trying to fight for changes in workplaces where there's inequality that's really deeply entrenched cannot always be worth it, depending on what's going on in your life and what you have going on. So it's just an option to think about, that sometimes it pays off to find a workplace that's going to value you and treat you with equality and respect.
Beautiful. Thank you so much, Kaylee. That leads us to our next question, which is for Catherine, and it's about making the complaint itself. So the question here is, do all human rights complaints get filed with the BC Human Rights Tribunal, or can you file them with the courts?
Human rights complaints under the BC Human Rights Code are filed with the tribunal, not with the courts. Human rights complaints under the Canadian Human Rights Act about federal matters such as airlines are filed with the Canadian Human Rights Commission. Most matters are filed with the BC Tribunal. I will note three things. The first is that some other tribunals can decide if discrimination happened. So you may have a choice about where to seek a remedy. So for example, in a civil claim against a strata, the Civil Resolution Tribunal can consider if a strata discriminated. In the union context, which Kaylee mentioned, a labor arbitrator can decide whether the employer discriminated. The second thing is that you do not file a discrimination complaint with the court, but you might file a related matter with the court. So for example, if you get fired, you might file a wrongful dismissal case in court, And that case may cover some of the same things that you've said in your human rights complaint. So the third thing to know is that if you have more than one case, you or the respondent can ask the tribunal to wait to deal with your complaint until that other case has finished. When the other case finishes, it may have dealt with the discrimination complaint, and if it didn't, you can then go ahead with the complaint at that time.
Beautiful. Thank you so much, Catherine. This next question is for you, Kaylee. What if you're in the situation where you feel like you've already suffered enough? What is there to be gained by pursuing a complaint with the Human Rights Tribunal?
Yeah, it's a tough one that a lot of clients do have to contend with. But what someone has to gain is, I think it really depends on the person, what they're looking for out of the process, and what's available given the complaint that they have. So, hypothetically, if someone were to file a complaint and go all the way through the process to a hearing at the tribunal and they succeed, the tribunal can make a number of orders or provide a number of remedies. The first one is an award for something called injury to dignity, feelings, and self respect. And that's or for short, we just call it injury to dignity. And that's really financial compensation for the impact and harm that the discrimination caused, including the emotional harm as well. So that's, yeah, like I said, that's a financial award for the harm that was caused. The tribunal can also make awards for things like wages lost because of the discrimination. They can order that the respondent compensate the complainant for the expenses that the complainant incurred because of the discrimination. They can also order the respondent do specific things like maybe order a landlord make specific changes to a property, like installing a wheelchair ramp, for instance, or order an employer provide equity and diversity training to its staff, things like that. And it can make a number of other orders, like declarations that what happened was discrimination, things like that. And oftentimes, not in all cases, but oftentimes, a complainant can get a number of these things by settling early without having to go to a hearing. So the mediation process or the human rights process involves an optional mediation, and sometimes folks can negotiate for things that they might want. Early on in the process, and the complaint can be settled if they get some of those things without needing to go to a hearing, which could also be, and it can also be a very helpful option. It doesn't mean that when you file it, you have to go all the way through the whole process. There can be ways of settling without it. And then in terms of other things someone might gain, I mean, this is just speaking sort of from the perspective of things I hear from my clients sometimes, not from my own perspective, but sometimes things that people say that they feel is sort of a sense of validation or vindication, or even a sense of empowerment after feeling disempowered after going through some discrimination. So that could be something that someone is really looking for out of the process and could get out of it. But really the advantages they're just going to be so different for everyone in terms of what people want and what the specific complaint is about.
Beautiful. Thank you so much, Kaylee. This next question is for Catherine, and it is, how exactly do you go about making a human rights complaint? Do you need to have a lawyer to make a complaint? And are there free or low-cost ways to get help?
To make a complaint, you fill out a complaint form and file it with the tribunal. You should know that there's a 1-year time limit to make a complaint, so put that date in your calendar. The tribunal can accept late filed complaints, but there's no guarantee that it will, so file your complaint on time if you can. You can fill out a complaint and submit it online through the tribunal's website, and I think there will be links in the chat. You can also download an electronic version of the complaint form and complete it, or you can print one off and fill it in by hand and send it to the tribunal. If you are urgently seeking a remedy, when you file your complaint, you should also apply to the tribunal to fast track your complaint. And again, there will be a link to that information. There's some backlog at the tribunal, so we need to know if there's urgency. Before you file the complaint form, take a look at the print form to see what information to gather before you file. So for example, you're going to need the names and addresses of the people you say discriminated, called the respondents. You're going to need the correct legal name of a respondent organization. And on the tribunal's website, there is information to help you find the correct legal name. You're going to need dates and details about what happened, so you can start thinking about who did what and when. You will need evidence later on in the process. Do not file it with your complaint. What's most important is to ensure that you've given the tribunal the information about the discrimination. So you need to consider how you will explain what happened is connected to the personal characteristic that your complaint is about. Kaylee explained earlier that it's that connection that makes something negative that happened discrimination. And sometimes we experience something negative and we experience it as discrimination. When you're filing a human rights complaint, think about how you would explain to someone else the connection between what happened and your personal characteristic. And I'll give some examples here. And this first one relates to an example Kaylee gave. So your employer makes everybody work Saturdays. Your religion requires that you don't work Saturdays. So you'd show the connection between that rule and your religion just by explaining that situation. Another example we've heard already is security following someone who is Indigenous around a store. And that person might explain that security was not following anyone else around the store who was not visibly Indigenous. And that might explain the connection. And then a final example is a landlord changes their mind about renting to someone shortly after finding out that person is pregnant or has children or receives income assistance. It's that short gap of time that might explain the connection. You do not need a lawyer to file a human rights complaint, but you may have questions. If you want help, see who can help on the tribunal's website, and there will be a link to that in the chat. I'll give you just two examples of free help that is available. The Amici Curiae, or AC Friends of Court, can help filling out forms. They have an Indigenous services group who can help complainants who are Indigenous. The Human Rights Clinic, where Kaylee works, they offer half-hour appointments where you can get help completing your form, and they also have an Indigenous legal advocate, but there are quite a few other options as well.
Beautiful. Thank you so much, Catherine. And the links that you mentioned, they are, I understand, in the chat, and also we will provide links to those resources in along with the recording of today's webinar for anybody who's looking to have those. Catherine, we have another question for you. What steps can I expect in the complaint process? Will I need to testify in front of the person who discriminated against me in the first place?
I'll start at the beginning of the complaint process and then come to testifying at the end. The first thing that happens when you make your complaint is the tribunal is going to review it to see if you filed it within the 1-year time limit, to see if it's about a federal matter, so that it should be filed at the Canadian Human Rights Commission instead, and to see if it sets out or describes possible discrimination. The tribunal may ask you for more information, and this is another time that you may want to get some help. So for example, AC Friends of Court they will help you to fill out the form on which you will give more information. If the tribunal proceeds, it will send your complaint to the respondents, and at this step, you can ask to apply to the Human Rights Clinic for representation. If you are an Indigenous complainant, you can tell the tribunal that you want to speak to an Indigenous navigator at the tribunal who will talk to you about the tribunal's process and incorporating Indigenous protocols into the process, for example. The first step in the process is called a mediation. This is a voluntary step. At a mediation, you work with a trained mediator who will help the parties to see if you can find a solution together. So this can help you find a solution early and avoid a hearing if that is something that you want to avoid. If you do not agree on a solution, then you start to get ready for a hearing. And the first step there is sharing documents between the parties to show what happened. At that point, the tribunal decides whether the respondent appears to have a basis for applying to dismiss the complaint without a hearing. So, for example, the tribunal might allow a respondent to argue that there should not be a hearing because there's no reasonable chance of proving discrimination. If the tribunal decides to hold a hearing, you continue to prepare, you exchange your list of witnesses and information about remedy. Before the hearing, there are more chances to try to resolve the complaint between the parties. And in fact, that's how most people resolve their complaints at the tribunal. Less than 5% of human rights complaints go all the way to a formal hearing. At a hearing, you testify about what happened and you present your evidence. The other side or their lawyer has a chance to cross-examine you. And yes, you usually testify in front of the respondent. Though since COVID, most hearings are virtual, so that you will be participating the way that we are today. You can also ask for a screen or other modifications to the hearing process. After a hearing, the tribunal member decides what happened, whether it was discrimination, and if it was discrimination, will order a remedy. Usually the tribunal member gives you a decision a few months after the hearing, and the decision explains their reasons for their conclusion.
Super. Excellent. Thank you so much, Catherine. This next question is for Kaylee. I'm worried that pursuing a human rights complaint will be stressful and time-consuming. What factors should I consider before filing a complaint with the Human Rights Tribunal?
Yeah, so I think the first thing to think about is whether the Human Rights Tribunal process can even give you the remedies that you're looking for. So, for instance, sometimes it's really important, or the most important thing for a complainant is to get like a heartfelt apology and admission of guilt from the respondent. And occasionally it is possible to get to negotiate for you to settle the complaint in exchange for the respondent giving you some kind of apology at the mediation or written maybe. But to be honest, it's hard to get things like an apology from a respondent for all kinds of reasons. And sometimes, even if even if a respondent does make an apology, it often doesn't end up being quite as satisfying for the complainant after they've had to negotiate for it. So like that's one thing to consider. If there's something that you want that is just going to be hard to get, if not maybe impossible through the tribunal process, then maybe it's not the right process for you. That being said, if you want an apology, but you also want other things that the tribunal can give, then the process might still be appropriate, and you might be able to you might have to compromise on parts of it, like wanting an apology, perhaps. Um, Yeah, and then the other thing to know is to think about before filing is all of the steps that are involved that Catherine just mentioned. As you could tell, there's a lot of steps, and not everyone wants to engage in all of those steps. So it's just important for you to know that before deciding whether it's something you want to go into. One of the steps Catherine mentioned is the document disclosure stage, and depending on what your complaint is about and what's relevant, it might mean that you have to provide documents that could be embarrassing or just are private to the other side, to the respondent, like maybe medical documents. And for some people, that's not at all a problem. And it's what they know they need to do to prove their case and they're fine with it. But other people might have something sensitive that they don't want included. And oftentimes you can remove the information that isn't relevant by redacting or sort of blacking out that information in your medical documents, as an example. But if it's relevant, sometimes it needs to be included. So might be hard to know in advance, but it is something to consider. But not all of your medical information is usually relevant. Very rarely is it all relevant. It's also important to know that the process is by default going to be public, or the decision that the tribunal makes is sort of by default public, which means unless you qualify for an exemption from this rule, there's a good chance your name and the details of what happened to you will be on that public decision. And for some, that's a real benefit because they want the respondent's name to be public, which would also be a part of the decision. But for others, they may just be more sensitive to that and may not want that publicity. So those are some important things to consider. And I mean, I think that the process is a really long process. It can be really challenging, and that's not to discourage folks from doing it at all, because for many people, it really does pay off in all the ways I talked about before, all the things that you can get from the process. But for some people, they're just simply not in a headspace or a place in their life where that's what they want to do. And I think it's just important to know what it involves, and make it the best decision for you.
Beautiful. Thank you, Kaylee. A follow-up question on the time component of it. You mentioned it can be a long process. What is the sort of average or maybe a range of the time commitment that you've seen for securing a hearing date, for the time invested in the actual process itself? What does that look like?
I don't have, the official stats before me or anything like that, so I can just speak from just generally what I've been experiencing. For a lot of people, from the time they file their complaint until they even hear back from the tribunal, and it can be sometimes up to a year. In defense of the tribunal, they are extremely busy. They are moving as fast as they can. They are working very diligently to rearrange their processes to try to make it more efficient. But sometimes it takes a really long time just to even between filing and really those other steps starting. That being said, they have been making some changes. Catherine can probably speak a lot better than I can to this, but they have been making some changes. So we're hoping that that timeline is going to be sped up quickly. But I don't know how that's going to play out yet. And then it really depends on how long the other steps take. I mean, sometimes it takes a really, sometimes mediation dates fall through and they get delayed. Sometimes there's a lot of applications that in the meantime that delay the process. So I see some complaints that can take like 5 years beginning to end, and other complaints that can be sort of beginning to end like 2 or 3 years. And if something's fast tracked, maybe even faster. So it really just depends on like what happens in that process. There's no sort of cookie cutter answer to like what every case timeline is.
Absolutely. And thank you, Kaylee. I appreciate your response, that there isn't a single response. I think what is important for someone who's considering making a claim is that this is a question of years from the sounds of it, not a matter of weeks or months to go through this process. Thank you very much. Kaylee, this last question before we turn to the live Q&A is for you. How can I set myself up so that my complaint has the greatest chance of success?
Yeah, so Catherine mentioned that when you are filling out a complaint form, you're going to have to provide, to the best that you can, the dates of what happened and a description of what happened. And I think a really good way to make sure you're doing that well is in advance, while the discrimination is happening or around before you file, is to start documenting. So that means writing down what's going on and keeping some kind of record. I recommend on a personal computer or phone or notepad, not on your work computer, which could get taken away if you lost your job, for instance. It also sort of a part of that documenting process also means saving any relevant documents. So if it's, for instance, emails that are coming to your work email, and it's involving the discrimination, let's say it's emails about the accommodation process, I recommend emailing those emails to yourself or saving them somehow in case you lose access to your work email at some point. I also think it's really important to maintain a filing system of all those documents so that when you need them, you can find them quickly and you don't kind of lose track of things. And I think that filing system should include you keeping a filing system of any communications you have with the tribunal or the respondent about your complaint. So you have sort of an organized place where all those communications are kept. And then there might be other evidence. So an example could be video, like security footage, security camera video footage. I would try to preserve that as soon as possible. Oftentimes, security camera footage automatically erases and gets overwritten within a few days or weeks of that day. So as soon as you can, I would request that that video footage be preserved. And if possible, you could even maybe request a copy. Also keeping a record of witnesses. So really common that we might say lose track of our old employees after we've left a workplace or they've left a workplace, and they might be an important witness, but you don't know their contact information or even remember their last name. So I would recommend, getting those witnesses name and contact information so that if you need to contact them later to provide a statement for you to testify at a hearing, that you actually can find them. And then when it comes to the complaint form itself, Catherine has mentioned how important it is to actually state that there is a connection between the protected characteristic and what happened. So she gave a number of examples that I think were really good. And I think just making sure that that's clear on your complaint form is really, really important. And it's one of the common mistakes I see is people not doing that. The last thing I'll say is that at the Human Rights Clinic where I work, we do have a short service clinic appointment where we offer 30-minute appointments to folks who might have a human rights complaint. And even though it's not one of our services to write complaints for people, if someone has questions while they're writing their complaint, we can often give them really helpful information to guide them in writing their complaint. So I understand those links are going to be up, as Paula said. And if someone really does need help, to come to that short service clinic and make an appointment and ask your questions there.
Excellent. Thank you so much. So I'm turning now to the questions that have come in, and thank you to all of our guests for submitting questions. I see there are a number of them here. I'm going to start with a question that was voted to the top. And this question is, I was told by the RTB, which is the BC Residential Tenancy Branch, that the arbitrators do not follow the Human Rights Code of British Columbia. Is this legal? Can a provincial organization just choose to opt out of these laws? Can any organization choose to opt out of these laws? So, Catherine, would you like to take a crack at that?
Sure. And then maybe Kaylee will jump in if she has information I may not have.
Perfect. Thank you.
I said earlier that some other tribunals are able to decide if discrimination happened. My understanding is that Residential Tenancy Branch is not one of those tribunals. And so a tribunal has to have that power before it can deal with your concern about discrimination. And I don't believe that the tenancy branch has that
power. I agree with that. That's my understanding too. And I don't think it's so much that they're opting out, but just that they simply are not empowered. They don't have the ability to, even if they wanted to.
Beautiful. Thank you. This next question it has a number of upvotes. It's broken down into parts. I'm going to read what I think is probably the main question here. which is about microaggressions. So what factors or actions are used to establish a microaggression behavior and its weighting factors? Kaylee, would you like to take this question?
Yeah, I can try this question, and Catherine, you might have more insight to add too. Um, so yeah, my understanding is a lot of the time, sort of one microaggression happening might not be quite enough to establish discrimination. I mean, it might depend on whether we consider something a microaggression or just just it's in and of itself a discriminatory comment. But yeah, like it's possible that one microaggression is not quite enough to establish it. But oftentimes, when someone's experiencing microaggressions, there's a pattern of it happening, and that's when I think keeping a documentary record of what's happening can be really helpful, because totally would be understandable for you to forget all those comments that and the dates and when they happened and maybe who exactly said it. So to keep a record could be good, because showing a pattern of microaggressions can be considered discrimination. I don't know if you have anything to add to that, Catherine.
The only thing I'll add is that sometimes people do file complaints about one incident, and sometimes what will happen in those cases is the respondent will come to the tribunal and they'll say that one thing that doesn't amount to discrimination, and the tribunal will make a decision about that, and it depends on the full context about what happened, like the details about what happened, the relationship between the people. And it will depend also if the person who experienced the microaggression is a member of a historically disadvantaged group and experiences a lot of microaggressions. And it may be that makes the microaggression very impactful for them. And the tribunal will consider evidence about the impact on the person if it's deciding whether it can proceed with a complaint.
Thank you so much. There were a number of questions I mentioned around microaggression. I'm going to refer to another one of the questions, which is the distinction between truth and microaggression. Is that something that you're able to speak to?
I'm not sure I understand.
Yeah, it seems to be related to intent, impact, context, and truth as components of the microaggression. Is that?
Well, I don't know if this is going to answer the question, but one thing I realized that I didn't mention when I talked about the definition of discrimination is that it's not a requirement that the person doing the conduct intended its actions or their actions. So intent isn't actually a part of it. What's more important is the impact that it had on the person. So there can be times, I think a lot of microaggressions would fall under the category of what that person might have genuinely thought was a compliment, but really was a microaggression. And even if that person genuinely meant it as a compliment, could still be discrimination, could still be a microaggression.
And I think the same applies to incidents that we wouldn't consider microaggressions, but things with clearly significant impacts, like being fired or denied a service. In many of those instances, there is no intention to discriminate. The person is not even consciously aware that they are taking into account someone's protected characteristic when they are behaving that way. It is just not relevant to the impact on the person.
Excellent. Thank you so much. This one is about a condo. Our family was treated differently in our condo. My son has special needs. The strata continued to enforce different rules against our family. Others doing the same thing weren't pursued with fines and harassing letters. Because I can't get anyone to admit that they said something bad about him, I haven't been able to get a substantive human rights complaint. Can you advise?
So, so we can't give legal advice about your specific situation, but generally speaking, what I'll say is that there's a lot of the time discrimination doesn't even involve a specific derogatory comment or something that makes it obvious that that person's conduct is because of a protected characteristic. And so most of the time, what the tribunal, no, maybe not most, I don't know the stats, but a lot of the time, what the tribunal is considering is all the surrounding circumstance to figure out whether they think that it was more likely than not connected to someone's protected characteristic. So it's really, really common to have a situation where someone's being treated differently, rules are being applied differently to them, maybe, and than it is to other people. And you can use circumstantial evidence and not just sort of the direct comments to prove discrimination. So I wouldn't say that the absence of having that very direct evidence should discourage someone from making a complaint if they want to. Obviously, it makes it easier to have something, especially if it's in writing or something, that makes it's just sort of an extra hurdle you don't have to go over, but it's still totally possible to prove a case of discrimination without that.
Beautiful. Thank you so much. I'm just going to turn to one last question before we wrap up today. Here's a question. What about people who can't file within a year because it will further negatively impact their safety or human rights, i.e. renting from the same landlord that is discriminating from you and can only file after you have moved?
I did mention that it takes sometimes a year for the tribunal to even screen in those decisions. We don't have control over that timeline. It could start happening faster, but that respondent, say a landlord, probably won't even find out about their complaint and that complaint until the tribunal screens it in and then sends it to the respondent. So that kind of could buy you some time. The other thing is that the Human Rights Code also provides protection from retaliation. So it's also illegal for a landlord, an employer, or anyone to retaliate against you by taking some kind of negative action because you've filed or participated in a human rights complaint. So if there is something negative your landlord does in response to getting a human rights complaint from you, you would also have protection under the code.
Beautiful. Thank you so much. Oh, go ahead.
I was just going to add one last thing, and that is, I agree with what Kaylee said. And if you are filing late, you will have a chance to explain to the tribunal your reasons for feeling unsafe in filing a complaint earlier. Although keep in mind there is the retaliation protection, and you can file a separate retaliation complaint form at the tribunal.
Excellent. Thank you. Thank you so much. And thank you, everybody. We are going to wrap up our webinar for today. In terms of the topic that we discussed today, discrimination and making a human rights complaint, there are a number of pages as well on the People's Law School website where you can find further information. I just wanted to turn back to our presenters and thank them once again for joining us here today. And I'd love to hear from each of you if there's anything that stands out to you today, whether it's something that we covered that you wanted to highlight, or something that maybe we didn't cover that you would like to leave with our guests before we wrap up today. And Catherine, I'll start with you.
If anything, as you were talking about the People's Law School website, I did take a look at it before the webinar, and I think there's really excellent information about human rights on that website. So there are lots of options. There's the tribunal website, the clinic website, the commissioner website. I wasn't familiar with this one, and I thought it was very good. So I highly recommend it to folks.
Beautiful. Thank you so much, Catherine. Kaylee, is there anything that you would like to share before we wrap up today?
I just always love the questions from the participants. It really helps. Like the question about intent, for instance, I mean, it helps me figure out where maybe my answer didn't quite explain what people need to know. It helps like fill in the gaps a little bit. So I just really appreciate the attendees and their like willingness to participate.
Thank you again, everybody. Thank you, everybody who joined us today. Thank you to our speakers. We look forward to seeing you at our next webinar. Bye for now.